5 seconds to go. Start. The sole appellant Mongal Soren has been convicted under Section 302 of Indian Penal Code and sentenced to imprisonment for life and fine of rupees 5,000 with default stipulation. The victim of incident was Dhani Tadu, aged 28 years. Dhani, after leaving her first husband, remarried to appellant. She therefore, along with her son, aged about 5 years, from her first husband, lived with the appellant in village Banga Para, falling within the jurisdiction of police station district Chirang. According to the prosecution case, on 30th November 2011, around 9:30 pm, the appellant dealt a blow with an axe on the stomach of Dhani. This he did in his house. The blow was so severe that it also cut the small and large intestine below umbilicus region and resulted into her death on the spot. The appellant then, on the following morning, went to the house of village headman and told him that his wife had killed herself. At that time, other villagers were also present. Thereafter, PW2, PW3, and PW6 and some co-villagers went to the house of appellant, where they found dead body of Dhani with a bleeding cut injury in abdomen. Seeing this, the public apprehended the appellant and informed the matter in the camp of Bircha Command Force. One commander from the Bircha Command Force reached the place of occurrence and took the appellant to the camp. Sundar Soren then made Ejahar Exhibit 5 at police station against the appellant. The police took the appellant into custody from the camp and brought him to his house. During interrogation, the appellant admitted that he had killed Dhani and also produced the axe. The police seized the axe wide Exhibit 3 in the presence of Sundar Soren PW6 and PW2. PW5 conducted the post-mortem examination on the dead body of Dhani. He found two blackish bruises over right maxillary region measuring 2 cm into 2 cm and a sharp cut injury over abdomen below umbilicus measuring 10 cm into 7 cm into 5 cm. The doctor also found cut injuries on small and large intestine. He, in his post-mortem examination report, Exhibit 2, opined that Dhani died due to shock and hemorrhage. At the stage of framing of charge, the appellant admitted his guilt, but the trial court, in all fairness, proceeded to decide the trial on merits by directing the prosecution to prove its case. The appellant, however, during his examination as an accused, pleaded false implication, though he did not deny that his wife Dhani died in his house on account of injuries in the abdomen. He also admitted injuries on her face. It is argued on behalf of appellant that in the absence of any eyewitness that he caused injuries to Dhani, the trial court committed an illegality in convicting him under Section 302 of the Indian Penal Code. The learned additional public prosecutor, on the other hand, defended the conviction and sentence of the appellant as passed by the trial court. In Ganesh Lal versus State of Maharashtra, 1992 3 SCC 106, the accused was prosecuted for the murder of his wife, which took place inside his house. In this case, the Supreme Court observed that when the death had occurred in the custody of accused, he is under an obligation to give a plausible explanation for the cause of her death in his statement under section 313 of the Code of Criminal Procedure. The mere denial of the prosecution case, coupled with absence of any explanation, was held to be inconsistent with the innocence of the accused, but consistent with the hypothesis that the appellant is a prime accused in the commission of murder of his wife. Stop.